So with that said, I am now going to introduce our main event for today, the managing partner over at our Tampa location, formerly of the Pompano office, Kirsten Henza. Kirsten, please take it.
Hello. Thanks, Jeff. That was a lovely introduction.
Welcome. You're very welcome.
Good afternoon, everyone. As Jeff mentioned, I'm Kirsten Henza. I am the managing attorney for the Hillsborough County office of KBR, which is located here in Tampa, Florida. So we're going to be covering the Condominium Association Board Member Certification materials. So I'm sharing here the outline that I'm going to be going over. There are a lot of words. I'm not necessarily going to read all the words verbatim. Like Jeff mentioned, they will be available for you to download at the end of the class. Okay. And, just again, as a reminder, this is very basic materials. Many of you are probably new to the board. So this course is intended really as an introduction for new board members, or a refresher course for existing board members. But we're not going to be going into a lot of depth in a lot of this material. We do offer other courses that are more in depth. For example, we have legal update where we discuss new legislative changes. We have fair housing courses. So we do have other courses that go in depth. All right, and then I'll stick around for a little bit afterwards to answer any questions. All right, so we'll start with the board member certification. Why are we here? Well, you're here because the condominium statute requires that within 90 days of a board member being elected or appointed, you have to get certified. And there's two ways of doing that. You can either submit a certificate confirming that you have completed an educational course that's administered by the division, such as the one you're attending today. And at the end of the class, you will get a certificate. Or in lieu of attending the class, you can certify in writing that you have read your governing documents and that you will uphold the documents and, to the best of your ability, will faithfully discharge your fiduciary responsibility. Okay, so those are your two options. That must be done within 90 days of being elected or appointed to the board. The attendance of your educational class, that can actually be done or completed within 1 year of being elected or appointed. Okay. Now, the certification does not have to be repeated. You don't have to get certified every year as long as you serve without interruption. So if you remain on the board for the next 5 years, your certificate is good to go. You file it with the official records of your association, and you're good. Now, if you end up getting off the board, even if it's for 1 year, and then rejoin the board the following year, you would be subject to the same certification requirements. Now, a director who fails to timely file the certification or attend a course is suspended from service until the board member completes the course or certifies in writing to having reviewed the governing documents. Okay. If you are suspended from service because of failure to complete one of the two certifications, then the board can fill the vacant seat for the remaining period of suspension. The certificates have to be retained as part of the official records for 5 years after the director's election, okay, or for the duration of the interrupted term. All right, now let's go and start let's discuss condominium associations in general. So, condominium association is an entity. It is a corporation, not for profit, and it's governed by two chapters specifically. Chapter 617 of the Florida statute. That chapter governs non-for-profit corporations. And then the association is also governed under Chapter 718, which is also known as the Condominium Act. Okay. The association is also governed by its governing documents, in particular, the Declaration of Condominium. When your condominium was created, the developer had to file and record a Declaration of Condominium. Okay, so that document is recorded in the public records. Okay, and really the declaration is, a contract between the association and the unit owners that bind to the condominium. Okay. All owners own an undivided interest in the common elements. Okay. Now, what are your powers and duties? The condominium association is responsible for the operation and the affairs of the condominium. Okay. Most of the powers that the association has are either in Chapter 617, Chapter 718, as well as in your governing documents. Okay. So the general grant of power of the association will include the power to sue, the power to be sued, to purchase or otherwise acquire property. You have the ability, the power to sell, to mortgage property. You have the power to contract. So the association has the ability to enter into contracts for maintenance and operations of the condominium. You have the authority to incur liabilities as well as to borrow money. So if an association, your association needs, money to borrow, needs to borrow money to, fund a construction project, or, let's say your milestone inspection, whatever it is, you have the ability to borrow money. And you have the authority to exercise any other powers that are, necessary to carry out your duties. Now, which year's statute applies? Okay. So this is a little bit of it's a little bit of a complicated concept. So I'm going to simplify it here. The law that is in effect, okay, the law that applies to your condominium association is typically the law that was in effect at the time that your declaration of condominium was recorded. Okay, because it's really the law that applies is the one that was in effect at the time of a contract was signed. And in this case, your declaration is the contract. So if your declaration of condominium was recorded in 1975, that's the law that, would typically apply to your condominium association. Now, many of you, may have heard of this phrase called, well, it's called Kaufman language, but it's a phrase that is added to a declaration, which is as amended from time to time at the end of reference to Chapter 18. So when you open up your declaration of condominium, it would typically, somewhere on the first page, will say that your declaration of condominium and your community is governed under Chapter 718 of the Florida statute. Sometimes, or some declarations, you might have reference to as amended from time to time. So your declaration is subject to 718 as amended from time to time. That phrase, as amended from time to time, is called Kaufman, okay, and it's derived from case law. And what it says basically is that if your declaration has that language, then every year when the laws change and new legislation goes into effect, those statutory changes will automatically be incorporated into your governing documents without having to amend the declaration every time. Okay. Now, if you don't have this language as amended from time to time, then, a constitutional argument could be made that the substantive changes to the Florida statute do not apply to your condominium. So a good example is there, many years ago, I don't know if it was 2004, there was a change in the statute concerning leasing of units. And the statute basically was amended to say that if you're going to amend your declaration to prohibit leasing, such amendment would only apply to those owners that voted in favor of the amendment and those owners that took title after the effective date of the amendment. Well, if you had Kaufman language when that change went into effect, then that statutory change automatically applied to your declaration. So if you were to later amend your declaration to prohibit leasing, you would be restricted as to whom the amendment would apply. Now, if your declaration didn't have that verbiage as amended from time to time, then you could make a constitutional argument that that statutory change did not apply to your community. And the reason it wouldn't apply to your community is because there's a constitutional principle that says that it basically prohibits retroactive application of the law to existing contracts. So you can't now pass a law that would affect a contract that was already in existence. Now, a key takeaway here is that this amended from time to time language really applies to substantive changes to the statute, such as the lease restriction that I just discussed. There are other changes to the statute which are known as procedural changes. Okay, those, a good example of procedural change would be if the Condominium Act was amended to change the election process. Okay, now statutory changes to 718 that affect procedural issues. So these types of procedural changes, they still would apply to your declaration regardless of whether or not you have Kaufman language. So what you need to basically, the takeaway here is that, speak with your legal counsel if you don't have this language amended from time to time as to whether that would be, beneficial for your community to include or not. Okay, there's pros and cons to including that language. Okay. Let's go on to conflicts between the declaration, the articles of incorporation, and bylaws. So we talked about your declaration of condominium, which is your supreme document. Okay, that is your contract between the association and the unit owners that bind the community. Then you have two other documents, your articles of incorporation and your bylaws. And the articles of incorporation and bylaws really address the corporate governance of the entity. So the declaration would address more of the use restrictions, whereas the articles and bylaws would address more of, who are the members of your association, who qualifies as a director, how are elections conducted, who can serve on the board, officer positions, that sort of thing. So in terms of hierarchy, your declaration is going to be your supreme, okay? And then underneath the declaration, between the bylaws and the articles of incorporation are going to control. And then lastly, your bylaws. Your bylaws really should not contain use restrictions. Okay, that's not, the appropriate place for them for use restrictions to be. All right, transfer and estoppel certificates. All right, so transfer fees concern really a fee that you can charge in connection with a sale, a lease, sublease, or a request for transfer of a unit that's other than a sale or lease. For example, if a unit is conveyed by quitclaim deed, that's not necessarily a sale. That's just a transfer. So, in order for the association to have the authority to collect a transfer fee, okay, or an application fee, you have to have language in your declaration giving you that authority. Okay. The authority can also be in your articles, or it can be in your bylaws, and presuming you have that authority to charge a transfer fee in connection with a sale or lease. Okay. And typically you would find that authority if your documents allow you to approve or disapprove a sale, lease, or sublease, or other transfers. Okay. Now, the statute says that the fee cannot exceed $150 per applicant. Now, this used to be $100 for many years per applicant. So this was the fee increased now to $150 per applicant, and it's for applicants other than husband and wife or child and parent. Those are considered one applicant. Okay. Now, if you get an application for a lease or sublease renewal, okay, then you cannot charge another transfer fee if the lease renewal application is for the same applicants, the same tenants. You also, the statute also allows the association to collect a security deposit from a tenant that wants to lease a unit in the condominium, provided you have the authority in your declaration or bylaws. So you might want to take a look at your declaration or bylaws to see if you have that authority. If you do, then the amount of the security deposit that you can collect really is for 1 month's rent. Okay. Now, the security deposit is intended only to protect against damage to the common elements or association property. Okay. You're not collecting the security deposit, to offset, any future assessments. So if an owner becomes delinquent at some point, you can't use the security deposit to offset that delinquency. It really is only in the event the tenant causes damage to any common elements or association property while the tenant is leasing a unit in the community. Okay. All right, estoppel certificates. All right, within 10 business days of receiving a request for an estoppel, the association has to issue this document called an estoppel certificate. And you may have even done it when you purchased a unit in your condominium, or may have recently seen it in connection with, another unit that's, for sale at the condominium. So what this estoppel certificate is, just go to the next slide. It's basically a document that contains all this information that you would need to disclose to the buyer. Okay, let me just condense here. Okay, so you would include, date of issuance, name of the owner, property designation. If there's a parking space that goes within a unit, you'll designate it on the estoppel. Attorney's name, if you have legal counsel. You'll identify the fee for preparing and delivering the certificate, the name of the requesting party, and then here's the sort of the substantive information that you would need to disclose. And by the way, this is language that's directly from the statute. Okay, so the statute tells you that this is the information that you would need to disclose on your estoppel certificate if a request for estoppel is made. Okay, so you'll identify your periodic assessments, your regular assessments, the next installment of your assessment, You'll identify any special assessments or any other monies that are due to the association. And then you would also have to identify any other assessments or special assessments that are scheduled to become due after you've already sent or delivered the certificate estoppel. You'll identify whether there is any transfer fee requirements, whether there are any open violations. Is the unit in violation for doing something contrary to the covenants? Is there a lease violation? Is there a maintenance violation? You'll identify all of those on the estoppel certificate. And you want to make sure that you identify all the information that the statute requires, not only because that's what the law requires, but you want to have you want to make the buyer aware. Okay, and you want the buyer and the seller to figure it out between themselves, who is going to address and satisfy whatever financial obligations or violations are outstanding, okay, before the closing takes place. All right, well, on a good note, the statute does allow the association to charge for preparation of the estoppels, and the estoppel can be prepared by a board member or an authorized agent, so it could be prepared by your property manager, even by your attorney, okay? And you can also charge a fee. So you can charge a fee not exceeding $299, okay, if there is no delinquent amounts owed to the association. So if the unit is not in delinquency and you're just filling out this certificate, then you can charge $299. If the unit happens to be in, delinquency or collections, then you can also charge an additional $179 for preparing the certificate for this particular unit. And then if if the request for the estoppel was made on an expedited basis, okay, and you delivered the estoppel within 3 business days after the request, then you can charge an additional $119 fee. Okay, in order to charge an estoppel fee, the authority to do so has to be established by written resolution adopted by the board or provided in a written management or maintenance contract. So if you have a management company, you may have seen in the management agreement, there should be at the end of the management contract a list of all the types of fees that the management company can charge an owner, and most likely you will find the authority to charge for estoppel fees in the contract. Otherwise, the board can also adopt a written resolution to that effect. Okay. Now, the association fails to deliver the estoppel certificate within the 10 business days of request, then you can't charge the fee. Now, the next slide, I'm not going to go into detail, but if the estoppel request is made for multiple properties owned by the same owner, then the statute provides for a separate schedule of fees that you can charge in preparing the estoppel certificate for those units. So for 25 units or fewer, then you can charge $896 and so forth. Okay. Now, the estoppel fees, they are adjusted every 5 years, okay? And it's going to be based on the adjustments made in the Consumer Price Index, okay? And it's the Department of Business and Professional Regulations, the DBPR, that's going to periodically, recalculate these fees, and then it will republish these fees on its website, okay? So the fees that you'll see on these outlines are the most recent updated fees. They don't match what's in the statute because the statute has the older fees. Okay. Now, the estoppel certificates, if they are delivered by hand or by email, they are effective for 30 days. If you deliver the estoppel certificates by mail, then they are effective for a little bit longer, for 35 days. Okay. Now, the statute also allows the association to charge a reasonable fee to a purchaser or parcel owner if, for example, they ask if they request information that's outside of the estoppel, and the association, answers the questions, that you can charge a reasonable fee as long as the fee does not exceed $150, plus the reasonable cost of photocopying and any attorney's fees that you may have incurred in answering a question for a buyer. Okay. And pursuant to, Chapter 718, Section 111, subsection 12E2, the condominium association and its agents are not liable for providing information in good faith pursuant to a written request, if the person providing the information on the estoppel includes a statement saying, "The responses here are made in good faith and to the best of my ability." Okay, so let's talk about other purchase and sale documents. So you have a condominium question and answer sheet. Okay, and then there's also the disclosure obligations of the selling owner. Okay, so the condominium question and answer sheet, all right, hopefully you've seen it. You should have it as part of your official records. It's, a single page document. You can obtain a form from the Division of Condominium website, and it essentially contains, several questions regarding your condominium. For example, what kind of use restrictions do you have? Specifically, do you have any restrictions on leasing? Do you have the ability to approve sale, the right of first refusal? It'll ask you questions about special assessments and whether the association is subject to any litigation which would subject the association to damages or liability of $100,000 or more. Okay, those are the general questions that are asked on the question and answer sheet. So you should, have that answered, and then that Q&A will be kept on file as part of your official records. When an owner buys, when you have a purchaser buying into your community, that Q&A must be provided to the purchaser. Now, the purchaser is also entitled to the following documents, okay, when they're purchasing a unit from a non-developer unit owner. So they're entitled to get a copy of the Declaration of Condominium, your articles of incorporation, bylaws, rules and regulations, and your frequently asked questions and answer sheet. The buyer is also entitled to receive from the seller this document called the governance form, okay, which is provided by the division summarizing the governance of the condominium association. So here in the next slide, I've identified what this governance form has to provide. And again, you should be able to get this from the division. So, it'll have to identify the role of the board in conducting the day-to-day affairs, the board's responsibility to provide advance notice of meetings, the right of owners to attend and speak at meetings, responsibility of the board and owners with respect to maintenance, remedies available to owners with respect to actions by the board, responsibility of owners with regard to payment of their assessments. It'll also address the voting rights of owners, etc. So you can read that in more detail when you download the slide. All right, and now to more fun stuff. The right of suspension. So suspension of use rights, suspension of voting rights, and fining. All right, so the association has the authority under the statute to fine and suspend unit owners, occupants, tenants, invitees, and guests for their failure to comply with the governing documents and rules and regulations. Okay. The authority to suspend and fine for violations of your covenants and rules does not have to be provided in your governing documents. The statute already provides that. It's one of those procedural changes to the statute that would apply regardless of whether you have Kaufman language or not. Now, the fine and suspension of use rights for violations have to be adopted in a two-step process, okay? The first process is that the board adopts the fine and suspension at the board level, okay? And this is presuming after you've already sent the violating owner or tenant, a few demand letters letting them know what the infraction is and what they need to do to correct the infraction. And if they don't correct the infraction, then you would be subject to a fine, or you would be subject to having your use rights suspended or the rights of your tenant or occupants to use common facilities. So once the board adopts the fine or suspension, okay, at a board meeting, with proper notice of that board meeting posted 48 hours prior to the meeting, then the fine and suspension has to be they have to be ratified by your committee. Whether it's you can call it grievance committee if you have one grievance committee for fining and suspensions, or you might have separate committees, one for fining, one for suspensions. Typically, an association, I haven't seen where an association has two different committees because it's generally difficult to find volunteers for these committees. These committees must consist of at least 3 members who are not officers, directors, employees of the association, or the spouse, parent, child, sibling of an officer, director, or an employee. So often it's hard to find these volunteers, okay? But you need to have a committee organized for purposes of doing step 2, which is the ratification of the fine or suspension, okay? So once the board adopts the fine or suspension, typically you'll send a notice to the violating owner saying, hey, because you violated our documents and you've not corrected the violation, we've adopted the fine or we've adopted the suspension, and now you have the opportunity to go before this committee to, contest the fine or the suspension. Okay, now that notice needs to be mailed out to the owner at least 14 days prior to the committee hearing. Okay, that's that 14-day notice. And then at the committee hearing, the owner can come and present evidence as to why the suspension or fine should not be imposed. And then the sole function of the committee is really not to negotiate the suspension or the fine. It really is a yes or no vote. It's either you ratify the fine or suspension, or you reject the fine and suspension. And only if the committee ratifies the board's vote, the fine or the suspension can go into effect. Okay. Now, in terms of the fine cannot exceed $100 per violation. Okay, and that can be levied on the basis of each day of continuing violation with a single notice. Okay, an opportunity for hearing, but cannot exceed 1,000. Okay, so if the violation is that you can't park commercial vehicles in the condominium, and the owner has a commercial vehicle and you've already sent them a letter, well, that's $100 for every day that that vehicle remains parked there, up to 1,000. Okay. Now, if the committee confirms the fine, okay, it has to be paid within 5 days after the date of the committee meeting. The thing about fines with condominiums is that the fine cannot become a lien. So if the owner doesn't pay the fine, well, you can't assess the fine against the unit and then lien and foreclose for it. So it's just a charge that's going to remain on the account, and hopefully the fine can get paid when the owner sells the unit. Now, with regard to suspension, keep in mind the suspension is really of use rights of common facilities. So your gym, your pool, your clubhouse. If you have the ability to control access to these facilities, then this could be a useful tool for enforcement. If you can, deactivate the fob, for example. If you don't have the ability to really control access to these facilities, then this might not be a useful enforcement option. What the suspension does not apply to is limited common elements that are intended to be used by a particular unit. So for example, a balcony. It would also not apply to common elements needed to access a unit. So the hallway, you couldn't suspend the right of an owner to use the hallway to get to his unit. You also can't suspend rights to utility services, so water, electric. You couldn't shut off utilities because an owner is in violation. And you also can suspend an owner's or really occupants, tenants, guests' use to elevators or parking spaces. Okay. Now, the association through the board also has the ability to suspend use rights of an owner, of an occupant, or of a tenant if the owner is more than 90 days delinquent in any monetary obligation due to the association. Okay, so if the owner is delinquent on assessments, late fees, interest, attorney's fees, or let's say, the committee confirmed a fine, and now you have $1,000, a fine sitting on the account, which hasn't been paid. Well, if the owner hasn't paid that fine for more than 90 days and he's delinquent, well, that's another way that the association can suspend use rights. The suspension really is only in effect until the monetary obligation is paid in full. If you're going to suspend use rights because of a delinquency, then that suspension only needs to be done at the board level. You don't need a committee to ratify that vote. You just need a board meeting properly noticed 48 in advance with a proper agenda item indicating that the board will be suspending use rights based on delinquency. And then once the board has taken action, then you notify the owner of the suspension. Okay, this slide is what we've just discussed, what the suspension applies for and what the suspension does not apply for. Okay, so another mechanism, enforcement mechanism, is for the association to suspend voting rights. So we've talked about fining and suspension of use rights due to violations, and then we've also discussed suspension of use rights due to delinquency. The last enforcement option is to suspend voting rights of an owner if And these are the two conditions. If the owner is more than 90 days delinquent on a monetary obligation to the association, and the delinquency is more than $1,000. Okay. Before you suspend the voting rights of this owner, you have to give them at least 30 days notice, letting them know of the delinquency before you can suspend the owner's voting rights. A little caveat with suspension of voting rights. So we talked about how the right to suspend use rights and the right to fine doesn't necessarily have to be in the declaration. You get the authority from the statute. Well, based on this recent case law that I've cited here from 2020, the holding of that case basically was that the association in this case had a declaration of condominium that didn't have Kaufman language and did not have an amendment specifically authorizing the board to suspend voting rights when the owner was delinquent for more than 90 days. And so the holding, what the court found basically is that the only way for the association to have suspended the voting rights of this owner was if they had Kaufman language or if they had amended their documents. So that's the singular case that we have seen on this topic. We haven't seen this case extended to suspension of use rights or fining for violations. So it seems to be particular to only suspension of voting rights. So the takeaway here is, in an abundance of caution, you might want to, take a look at your governing documents, see if you have the ability to suspend voting rights. And if you don't, might want to consider then an amendment to specifically give you that authority. So when you suspend voting rights, what that means is that, that unit would not be counted towards the quorum requirement and would not be counted towards the voting percentage required on, an issue that the owners might vote. So, for example, if you're trying to get amendments passed in your community, and let's say you have 100 units, and you need a vote of a majority of the units, which is 50% plus one, and you have a number of owners who are delinquent, and presuming that you have properly suspended, that you have proper authority and you've properly suspended the voting rights of these delinquent owners, and let's say, you suspend the voting rights of 20 owners, then that means that now the voting requirement or the voting percentage you need to get these amendments passed would be a majority of 80 as opposed to a majority of 100. So for many communities, that could be effective in getting, certain actions passed on which owners need to vote. All right, so let's move on to meetings. All right, gosh, time is going by really fast. All right, so membership meetings. To summarize, you're going to have really two types of membership meetings. You're going to have your annual meeting. Okay, that's typically the meeting at which you're going to have your election. And then you might have special membership meetings, throughout the year if there are certain issues that owners need to vote on. Otherwise, really, your annual meeting is going to be the one and only membership meeting you might have in your community. Okay. All meetings have to be properly noticed. Okay. They must include the date, the time, the location of the meeting, and they all have to include an agenda. What are you going to be discussing at that meeting? So be sure to identify each agenda item. Except for elections, for annual election meetings, which we'll talk about in a minute, notice of a special membership meeting needs to be mailed, hand delivered, or it can be electronically transmitted. So it can be sent by email to those owners who have consented to receiving notice by email. And that delivery has to be done at least 14 days prior to the meeting. And the notice also has to be posted somewhere conspicuously on condominium property at least 14 days prior to the meeting. Okay. Proof of notice. Proof of notice is typically done through an affidavit that must be completed by the person that mailed or delivered the notice. Typically either the secretary or the property manager. Electronic notices. So like I just mentioned, notices can be mailed, hand delivered, or emailed. Okay. But they can only be emailed to those owners who have consented to receiving notices by email. So you need to have a written consent from those owners. If you just have these owners' emails, that's not necessarily written consent. Okay, so while you might, in that case, send a courtesy copy of a notice by email, the official notice should then be mailed out to this owner. Okay, quorum at membership meetings. Unless a lower number is provided in your bylaws, quorum of association members at a meeting is a majority of the total voting interest. That means, again, in a unit that has 100 units, majority would be 50% plus 1, so 51 owners would be quorum. And in terms of the decision of the board in terms of the voting percentage necessary for members to take action, unless your documents say otherwise, then the decisions of a majority of the voting interest at a meeting at which quorum is present, okay, will determine the action. So what that means is if a quorum of 100 units is 51, and let's say that's the minimum number of owners that show up at that meeting in person or by proxy, then it would be a majority of the 51 owners present that would determine the action. Members have the right to speak at members' meeting with regard to all agenda items up to 3 minutes. This is why having an agenda on your notice is important, because you're limiting discussion to only those items that are on the agenda. A unit owner may record and videotape meetings as well. Okay, voting by proxy. Voting by proxy is permitted. Okay, there's 2 types of proxies. There's general proxy and there's limited proxies. And general proxy allows a proxy holder to vote, okay, as to general matters. Now, a limited proxy, okay, would have to specifically identify the issue that's before the membership that requires a vote. The Condominium Act specifically says that you need a limited proxy for these particular issues. So owners cannot vote by general proxy. You need a limited proxy to take a vote on waiver or partial funding of reserves. Okay. You need a limited proxy for votes taken to waive financial reporting requirements, to amend the declaration, articles, bylaws, okay, or any other matter for which the Condominium Act requires or permits the vote of the unit owners. Both general proxies and limited proxies may be used to establish quorum. Okay, and the proxy is good for the particular meeting. Okay, and it is effective for 90 days from the particular meeting. So let's say you're amending your governing document, your declaration, and you set a meeting for January 1st. And January 1st comes and you've collected a bunch of votes and proxies, but you just didn't get enough votes. That limited proxy for the January 1st meeting is good for 90 days from January 1. So that means that you can recess and reconvene your meeting as many times as necessary to try to achieve that vote up to that 90th day from January 1. Okay. A proxy is also revocable at any time at the pleasure of the member executing it. Now, in lieu of voting at a meeting in person or by proxy, there is an alternative option, which is taking action by written consent. Okay. The only way you can take action by written consent in lieu of a meeting is if you have the authority to do so in your governing documents. And with this process, basically, instead of having to hold a meeting, you will send out a, consent form, basically identifying what you want owners to vote on. If it's amendments, here's a copy of the amendments. Please, if you are in favor of these amendments, then execute at the bottom of this consent form and return the consent form. So really, only if you're in favor of these amendments would you execute the consent form and return it. Okay. And those consent forms, from the minute that you receive the first executed consent form, you have 90 days to collect the votes that you need. Okay. And once you collect all the necessary votes, then you can go ahead and record the amendment. So that's how the consent process works. All right, elections. All right, for elections, there is no quorum requirement. So you don't need to have quorum in order to conduct an election. What you do need in order to conduct an election is to receive election ballots from at least 20% of the eligible voting interest. So as long as you have election ballots from at least 20% of your membership, you can conduct your election. Okay. Condominium election is regulated by Chapter 718. Now, the next slide here are the important dates you need to know for condominium elections. I have seen many governing documents which describe a different type of election process for condominiums, or different date requirements. Okay, the Condominium Act will trump and control over what is in your governing documents as to elections. Okay, so as of now, the statute requires that you mail out your first notice of your annual meeting at least 60 days prior to your annual election meeting. And again, it could be mailed, delivered, or electronically transmitted to those owners who have consented to receiving notices by email. Then those owners that are that want to run for the board, okay, they have to provide written notice of their intent to run for the board at least 40 days before the scheduled election. And then, a candidate might want to, the board to disseminate, like a little biography. It's called an information sheet, telling the membership a little bit about themselves, what they've done, why they qualify for the board, if they want the association to mail those out with the election ballots. Okay. The statute provides that the information sheet cannot be longer than 8.5 by 11 inches. And it must be provided to the association at least 35 days before the election. And then finally, your second notice of the annual meeting, okay, with the agenda of your annual meeting, has to be mailed out to the membership, or hand delivered, or electronically transmitted to those who've consented to email at least 14 days prior to your election. And it is with that second notice that you're going to include these information sheets, you're going to include the election ballot, and you're going to include the inner and outer envelopes that owners would need to use in order to cast their ballot. Okay, and if there are any other agenda items that you're going to be discussing at the meeting, then you might want to include also a proxy, general proxy or a limited proxy. Okay. Elections are decided by plurality of the ballots cast. If the number of vacancies equals or exceeds the number of candidates, then no election is required. Okay, so those candidates that are listed on the ballot will just be seated by acclamation. We'll talk about official records in a little bit, but essentially any document related with the annual election meeting, your ballot, signing sheets, voting proxies, they have to be kept for at least 1 year from the date of the election. And then any challenge to the election process must be commenced within 60 days after the election results are announced. Board member candidacy. Okay, candidate is an eligible person who has timely submitted a written notice of intent to become a candidate. You have to be eligible to be a candidate no later than 40 days prior to the annual meeting, which would be the deadline by which you have to submit the notice of intent to run. So that's your last day by which you have to become eligible. Okay, and we'll talk about next what does it mean to be eligible. So a person who has been convicted of a felony, okay, you're not eligible to, run for the board unless the felon's civil rights have been restored for at least 5 years. A person who has been suspended or removed by the division, not eligible to be a candidate. Person who is delinquent in the payment of any assessments due to the association as of the deadline for submitting the notice of intent to run is not eligible to be a candidate. So you can't have that individual's name listed on the ballot. It used to be that the individual had to, if the individual was delinquent in any monetary obligation, not just assessments, then he or she wouldn't qualify. But now there's a change in the statute that says the only delinquency that counts is delinquents on assessments, not anything else. Co-owners. Okay, if you're in a condominium association with more than 10 units, co-owners cannot serve as members of the board at the same time unless they own more than 1 unit or unless there are not enough candidates to fill vacancies. Once a person is elected to the board, if that board member then becomes delinquent, okay, on any monetary obligation for more than 90 days, then that board member shall be deemed to have abandoned his seat on the board. Okay, so that board member would then be automatically off the board. Is more than 90 days delinquent. Okay, number of directors that can serve. So unless otherwise provided in your governing documents, okay, the board of a condominium association shall consist of 5 members. Unless you have a condominium which has 5 or fewer units, and then you must have a board of at least 3 members. So check your governing documents, check your bylaws to see if it provides how many board members must serve. Otherwise, it's 5. The term will expire at the annual meeting, unless, of course, for example, you have staggered terms in which case the term doesn't expire at every does not expire at every annual meeting, but perhaps every 2 years. That would depend on your bylaws. A director can serve for a term of more than 1 year. Okay. However, A director cannot serve for more than 8 consecutive years unless approved by 2/3 of the votes of the membership, or unless there are not enough eligible candidates. Now, keep in mind that this was a change in the law that took effect July 1st of 2018. So this 8-year consecutive term, really you start counting as of July 1st, 2018 forward. So if a director had served on the board for 10 years prior to July 1st, 2018, it doesn't count. You start counting as of 2018. Okay, on the date of the election, the first thing you're going to do after you call the meeting to order is typically verify outer envelopes. And there's 2 ways of doing it. You can do that either at the annual meeting, right at the beginning, or you can have the verification process done by an impartial committee in advance of the annual meeting. The outer envelope verification basically means that, the outer envelope, there's going to be a space in the envelope where owners have to identify their unit number and then sign the outer envelope. Okay, and then inside the outer envelope, you're going to have the inner envelope that's going to contain the election ballot. Okay, so the verification process of the annual envelopes is basically, the volunteers will be, confirming that the individual that signed the outer envelope is in fact an owner. You're going to compare that against a unit roster that you will have printed. Okay, so before any outer envelope can be opened, the volunteers have to go through all the outer envelopes and then just verify the outer signatures. Now, if the board wants to do that in advance of the annual meeting, that's an option. Just got to make sure that this is done by an impartial committee consisting of members who are not current board members, officers, or candidates for the board or their spouses. And that has to be done at a properly noticed meeting, 48 hours notice posted in advance. And that meeting is open to all the members. So owners can come in and watch this committee verify outer envelopes. Any outer envelope that is not signed by an eligible voter must be marked disregarded. You don't throw away that ballot, you keep it still as part of your official records. Now, once all the outer envelopes are verified, then once at the annual meeting, once the first outer envelope is sliced through open, okay, then the polling ends. Up to that point, while you're still verifying envelopes, if you're doing it at the election, any owner can come in and bring in an election ballot. So polls close when the outer envelope is sliced open. And then once you do that, you take out the inner envelope, and then you take out the ballot from inside the inner envelope, and then you start counting the ballots. All right, officers. In the absence of any provision to the contrary in the bylaws, the board shall have a president, a secretary, and a treasurer. Officers serve without compensation. Officers are appointed by the board, and this is typically done at an organizational meeting immediately following the annual meeting. So once you adjourn the annual meeting, the board can then move on to their organizational meeting, call the meeting to order, and then organize officers, appoint who's going to be the president, vice president, treasurer, secretary, etc. Now, directors cannot vote by proxy or secret ballot at board meetings, except secret ballots can be used by board members when appointing or electing officers. Okay, and there's nothing that prohibits a change of officers, midstream. All right, electronic voting. I'm not going to go into the details of electronic voting. You can read that at your leisure, other than to say that, electronic voting is something that the board can establish or adopt for your community, if that's the desire of the board. And it has to be done at a board meeting by written resolution, and notice of that board meeting at which the board's going to adopt e-voting has to be, mailed, hand delivered, or electronically transmitted to owners at least 14 days prior to the meeting. Owners who cast, once the board adopts the e-voting process, it's not an automatic. It doesn't mean that all owners will now automatically have to cast their vote electronically. Owners still have to opt in to the system. So they have to consent in writing to, voting electronically. Those owners that choose not to consent to e-voting will continue to cast their vote the old-fashioned way, via limited proxies or in person at the meeting. Okay. Now, right here, I've just identified once the board has decided on a vendor to provide the e-voting platform for the association, the statute requires that the platform be able to authenticate and undertake some of these requirements here, which are outlined. Okay, so this is really more for that, third-party vendor to make sure their system complies with the statute. All right, board of directors, fiduciary duty. So officers and directors, you have a fiduciary responsibility to the unit owners. You must act reasonably, and you must exercise your best efforts to carry out your fiduciary obligation. Unless your documents provide otherwise, board of directors serves without compensation. The board is responsible for carrying out the duties of the association, and no one board member should be making unilateral decisions. Meetings of the board. When does a meeting of the board member become a board meeting? Well, a meeting is any time a quorum of directors is present to conduct association business, which means when a quorum of directors get together to vote on issues. Okay, so if you have, quorum of directors that is meeting, to workshop, or to hear out a couple of vendors that the board is looking to hire to undertake certain maintenance, unless you're voting on a particular vendor contract at the time, in our opinion, wouldn't be considered a board meeting. Now, at the next board meeting, you should have a discussion, okay, of the different vendors that you saw, and how the board is leaning, and then cast a formal vote. Now, from time to time, the board, might take action outside of a properly noticed board meeting. Sometimes the board needs to take emergency action. Doesn't have time to notice a board meeting with 48-hour notice. The law does provide for the ability to ratify those board actions at the next properly noticed board meeting. That doesn't mean that the board should be getting in the habit of, taking action without properly noticed board meetings and then just ratifying. Okay. Board members may use email as means of communication, but cannot use email to cast a vote. Just move on to the next slide in the interest of time. All right, board meetings. Typically, meetings of the board have to be noticed. Non-emergency meetings have to be noticed 48 hours in advance. You're still going to identify the date, the time, the location, your agenda for that meeting, and then you post that notice on condominium property where you typically post notice 48 hours prior to the meeting. The statute does require, though, that if the board is going to adopt a non-emergency special assessment, or if you are going to adopt rules concerning unit use, those meetings have to be noticed 14 days in advance. You have to mail out a copy of the notice to the owners 14 days in advance, and then post a copy of that notice on condominium property. And then you'll need to get an affidavit of mailing, again, affirming that notice was properly provided to the membership. Again, the notice has to identify agenda, typically, either the board is going to set, if the documents provide, the board can set a schedule of regular board meetings, or if the board desires, it can notice special board meetings if there's specific issues that need to be addressed between, regular meetings. Otherwise, 20% of the voting interest can also petition the board to place an item on the agenda. So if you do get a petition from 20% of the voting interest, then the board, within 60 days of receipt of that petition, needs to place an item on the agenda for your next board meeting. So it would be up for discussion. Meetings of the board of directors at which a quorum is present is open to all unit owners, except meetings between the board and the association attorney with regard to any proposed or pending litigation, or meetings held for the purpose of discussing personnel matters. So if you're discussing, a lawsuit, or, the possibility of being sued or of suing someone, that as long as you're discussing that with association counsel, that meeting is exempt. You'll still notice the meeting with 48 hours in advance, but you'll identify in the notice that the meeting is closed. It's with association counsel. Similarly, if you're going to discuss personnel matters, if you're, let's say discussing, maybe terminating an association employee or management company, that would be considered a personnel matter. Owners also can tape and video record meetings of the board, and they have the right to speak in reference to any designated agenda item. Quorum of the board is typically a majority of the board members present. Board members can also appear by telephone through speaker. Okay. So any director that is present at a meeting, via, video conference or speakerphone, they are considered present for quorum purposes. Committee meetings. A meeting of the committee. Okay, if the committee is taking a final action or is making recommendations to the board regarding association budget, they're subject to the meeting notice requirements. Okay, they're not exempt just because they're a committee. Committee meetings that do not take final action or make recommendations to the board regarding association budgets They still have the same requirement. However, they can be exempted from the mandatory notice requirements only if you do an amendment to your bylaws to exempt these meetings from the notice requirements, okay? You would need to amend your documents to allow that exemption. Otherwise, committee meetings are noticed just like any other board meeting with 48-hour notice. Conflict of interest, I'll just briefly mention, okay, directors and officers and relatives of directors and officers must disclose to the board any activity that may be reasonably construed as a conflict of interest. There's a rebuttable presumption that there's a conflict of interest if you have a director or officer or a relative of director or officer that has entered into a contract for goods or services with the association, or you have a director or officer that has an interest in an entity that has entered into a contract with the association. Now, as long as that contract is properly adopted and ratified in accordance with the statutory requirements I've set out here, okay, then, you know, it's okay. The statute doesn't necessarily prohibit those types of contracts between the director and the association. But again, the contract has to be properly disclosed. It has to be properly approved by 2/3 vote of the other directors. The interested director would have to abstain from that vote. And then importantly, that contract has to be disclosed to the membership at the next membership meeting. Okay, and those owners can then vote by a majority vote to cancel the contract. Okay, there's some more slides for conflict of interest. So how to get off the board. Basically 6 ways. A director can resign in writing. Membership also has the option to recall a director. The membership votes the directors. The membership gets to recall directors. A recall can be done with or without cause by a majority of the voting interest. And some slides later on provide you with a brief procedure of how recall can be done. If the director is delinquent in the payment of any monetary obligation due to the association for more than 90 days, director abandons his seat. Criminal charges involving theft or embezzlement of association funds, another way you will be removed from the board. If there are any known or violations of the Condominium Act, and then of course, failure to satisfy your certification requirements. All right, let's move on quickly to budget reserves and financial reporting. The board must adopt an annual budget. This is an annual obligation that has to include estimated revenues, operating costs, and reserves for the upcoming fiscal year. It has to identify the beginning and ending periods of your fiscal year and the total assessments for each unit type. Okay, but in the slide here, the budget of the association must include minimally the following types of expenses. Okay, administration, insurance, taxes, fees payable to the division, reserves. The budget adoption process, typically the board adopts the budget. Okay, you have to mail the notice of the meeting at which you're going to adopt the budget along with the copy of the proposed budget to the membership at least 14
Kirsten, you froze. I'm not sure what everybody else is seeing. I am going to enable the chat for a second here. And so you could all let me know if you are also seeing the issue. A few people, I just enabled the chat. Can you let me know if Kirsten looks frozen? Okay. Yeah, we lost her. All right, so let's hang on for a minute. Let her chat get back in. I'm going to text her right now. Bear with me, and in the meantime, we'll go over how to do the evaluation because we have about a half an hour left anyway. So let me text her and let her know. Rose, and we lost you. Come on back. Technology is great when it works, isn't it? She's saying that internet went down in the office. It must be having an issue. So she's going to keep trying to connect. In the meantime, what we're going to do is I'm going to put the evaluation into the link into the chat. And then you'll fill out the evaluation. Looks like she's coming back in. Okay, she's trying to, there she is. All right. You just missed my performance. I did some karaoke while you were gone. And no, I'm kidding.
I lost internet connection. How is that possible?
All right, so we're going to have Kirsten continue. We'll go over the evaluation in about 20 minutes or so when she's closer to the end. And then, yes, you'll be able to get the slides by filling in the evaluation. You'll then get a link to do the slides, but I'll go over that all once again at the end when we place the link into the chat. So Kirsten, back to you. Are you able to share got the screen share going? Looks like she froze again. All right, frozen again. All right, so it looks like she's having some technical issues with the internet service at the office. This is not the equipment failure on her part, but it looks like it's the service. So let me place I'm going to place this link into the chat now. Evaluation link. Here's the evaluation link. Click on that. And when you click on that, it'll take you to this page here. So click on the evaluation link. And once you click on that link, it takes you to this page. You go ahead and you fill it out. You submit it. Okay. And after you hit submit, the screen that you will then see is a confirmation screen confirming your submission. It looks something like this. It is your certificate. So if you're a board member that needs the certification for condo, click on that link right there. Your printer dialog box will open up. You choose your printer, then you can go ahead and print it. Also within this yellow shaded box, it says click here for the slides. You can click on there and you get your slides, all of them, even the ones that we skipped over that were not covered for time's sake. You can go ahead and do that as well. You'll get every one of the slides. So you go ahead and do that. I see she's back. I'm going to stop the share. Oops. Okay. So you have control back now to share, but it looks like you have an unstable connection there. It's not you, it's your service. It's not anything with your equipment, but try the share and let's see what happens.
Can you see it? No?
Not yet.
Okay. Yeah, and I'm so sorry, not sure what's going on.
Technology,
Ooh.
bad word. Stuff happens. Don't worry about it. It's you can't. It's beyond your control. There you go. Now we can see it.
All right.
I will shut up and I'll be back if we have another technology issue.
All right. So we were just talking about budgets. So not only does your budget have to include the operating expenses, you have to include reserves. So you're going to have to include a reserve schedule for the following items: roof replacement, building painting, pavement resurfacing, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. I'm not going to be discussing the requirements for the structural integrity reserve study and whether, you know, your unit, your condominium qualifies, whether it's 3 stories or not. Just know that whether you are over 3 stories or you are under 3 stories, these statutory requirements that I'm talking about here have not changed. They remain in the statute. The structural integrity reserve study is, yes, it only applies to condominiums with buildings of 3 stories and higher, but these statutory reserves still remain in place for those condominiums as well. Okay. So in terms of computing your reserves, yeah, you're going to have a reserve study, you know, done. Not talking about CEUs here, to evaluate your reserve components and then determine, you know, the useful life of the items, the remaining useful life of the reserve items, the replacement cost, and then your reserve schedule also has to identify your estimated fund balance at the beginning of each budget period. Now, the funding of reserves is an annual obligation unless the board wants to give the owners the option to either waive reserves or to partially fund those reserves. Okay, and the vote that you would need to waive or partially fund reserves is a majority of the voting interest. This was actually one of the changes that took effect July of this year. It used to be that you needed only a vote of a majority of those owners present at a meeting at which a quorum is present, okay, which is a much smaller percentage. Now the percentage is a little bit higher. You need a majority vote of all the owners. Okay, reserve funds are only to be used for the reserve item. Okay, so painting reserve funds can only be used for painting. Okay, if you want to use reserve funds for alternate purposes other than for which they were intended, then you also need a vote of the owners. You need a vote of the majority of the voting interest, majority of all the owners. Okay, you have the option to pool reserves in a single account. What I had previously described was having straight line reserves accounting. Okay, now you have the option of pulling all of these reserves in one account, and the benefit of that is, let's say you have a pooled account of, you know, painting and for painting and roof replacement, and you know, this year you need to replace your roof, but you don't have enough funds for that. You can take from the painting reserves without getting a membership vote as long as those funds are pooled. So something that, you know, might be beneficial for your community, speak to your accountant. If you are not currently pooling and you want to pool reserves, you need a vote of the majority of the voting interest. Okay. And if you are presenting the issue of waiving of reserves or partially funding reserves to the owners, then your limited proxy must contain the language here in red in all caps. So make sure when you're management or you do your notice on that you contain that language. All right, financial reporting requirement. Quickly here. So within 90 days of after the end of your fiscal year or annually on the date provided in your bylaws, the association has to prepare a financial report of the preceding fiscal year activity. So for example, if you have to do an audit, your audit has to be completed within 90 days after the end of your fiscal year or whatever date is provided in your bylaws. And then within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, you have to either provide a copy of the financial report to the membership or at least a notice letting them know that the financial report has been prepared, is available, and will be provided to the owners upon written request free of charge. Let me just go here to the levels of financial reporting. So under the statute, there are different levels of financial reporting depending on your annual revenue. So your level will depend on the total annual revenues of the association. So for example, if your association's total annual revenue is at least 300,000, but less than 500, the financial report that you need to prepare is reviewed financial statements, something that your accountant can prepare. If your total annual revenue is more than 500,000 or more, you have to do a financial audit per statute. Notwithstanding these financial reporting levels, okay, if you have a requirement in your bylaws to prepare a financial audit, even if your annual revenue is only 150,000, let's say, if your bylaws require you to do a financial audit, then you have to do the financial audit unless you amend your documents to remove that requirement. Okay. All right, a few gems all board members should know. So we're just gonna go through just a few other topics. Meeting minutes. You have to take minutes of all your meetings. Membership meetings, board meetings, committee meetings. Okay. And your minutes do not need to be and should not be a verbatim record of what transpired. You're not there to transcribe, everything that everybody said or discussions. It really should identify, who was present. Let's say at the board meeting, which directors were present, which directors were absent, the motions that were taking, perhaps, a very brief discussion if necessary, and then, record the vote that was taken at the meeting. Outgoing board members, okay, must return official records and property of the association to the incoming board within 5 days after the new board and committee members are elected or appointed. Access to units. The association has an irrevocable right to access each unit during reasonable hours, when necessary, for maintenance, repair, replacement of the common elements, or any portion of the condominium property that the association is required to maintain under the governing documents, or in case of an emergency. So if there is an active leak that the association has been notified of, you have an irrevocable right to access that unit under emergency circumstances if the owner is not there to stop the leak. If you're going to, force access to the unit, try initially to get in touch with the owner. And if you can't, then, recommend that you videotape your entrance into the unit and your exit out of the unit, for liability purposes. If there's time to contact an off-duty police officer to be present there, that's even better. Okay, the board also has the board can adopt rules and regulations, provided you have the documentary authority in your governing documents, and that can be rules about use of common elements, facilities, or unit use. Okay. If you're going to adopt rules concerning, common elements or facilities, that can be done at a board meeting that's noticed at least 48 hours in advance. If you're going to adopt rules concerning unit use, for those rules, you have to mail notice of the meeting at which you can adopt them at least 14 days before the meeting. And then once the rules are adopted, for the rules to become effective, you need to provide a copy of the rules to the membership before these rules become effective. Okay. Maintenance. That's the obligation of the association to maintain condominium property, the common elements. Okay, your declaration of condominium will typically identify what the maintenance responsibilities are of the association and then of the unit owners. Okay, you may have heard the term material alteration to the common elements. That applies when the association wants to undertake an alteration to the common elements. And in the next slide, just going to skip here quickly. I provided here the definition of what is a material alteration. This is a definition that comes from case law. It means to palpably or perceptibly vary or change the form, shape, elements, specifications of a building from its original design or plan or existing condition. Okay, so the division has determined that if you're going to change the color of the exterior building paint, that is a material alteration. Okay, and what the statute provides is that unless otherwise provided in your declaration, before the board can undertake a material alteration, or in this case, change the paint color to the building, you need to get the approval of 75% of the voting interest. There is an exception to the material alteration vote, which is the necessary maintenance exception. So if the alteration is a necessary maintenance and part of the obligations of the association to maintain, then in that case, you can undertake the alteration without the membership vote. Unfortunately, paint is just not one of them, according to the division. But the way this exception came up is in a case involving restoration of a seawall. Condominium had to, restore the seawall, and in doing that, there was going to be some alteration to the seawall. The court in that case said that nope, that was a maintenance responsibility of the association. They had to restore the seawall, even if owners objected. So they were able to proceed without a membership vote. Okay, emergency powers, not really gonna get into a lot of detail here, but this became, I guess, more important as a result of COVID. So we've provided here what the emergency statute provides now. There were some tweaks in the statute after COVID. Okay, among the notable changes here was that it now allowed board and membership meetings to be conducted, virtually. When during COVID, it was still unclear whether virtual meetings were proper under the circumstances. Most practitioners took the position that it was. Well, now the statute codified that, and now it is. So I will leave the statute here for you to read at your leisure. All right, leasing approval and amendments. If you have the authority in your declaration to approve or disapprove leasing, okay, then the board can do that. Ideally, you want to have your declaration identify the good cause criteria upon which you can disapprove a lease, which can be, negative financial history, negative criminal history. In red is what I kind of mentioned earlier on about the statute, that it was amended in 2004 to now say that if you're going to amend the declaration to prohibit leasing or limit or change the leasing terms, then those amendments would only be effective upon those owners that vote in favor of it and those that take title to a unit after the effective date of the amendment. So those owners who do not vote in favor of these lease amendment restrictions, well, they're not bound by them, and the association wouldn't be able to enforce it legally against them. Since we're talking about amendments, if your declaration is silent as to the membership approval that you would need to get to amend the declaration, the statute says you need a vote of 2/3 of the membership. Otherwise, whatever your declaration provides is what you would need. When you do amendments, the statute says you actually have to type up the actual language of the declaration that you're amending, and then you have to designate the changes either with underlines if you're adding changes, or by striking out language if you are removing language. If you're undertaking changes that are so substantial, then an alternative is, rather than underlining and striking through, you would just do your changes without, redlining, and then at the top of your declaration, you would put verbiage that's here. Substantial rewarding of a declaration, see provisions for the present text. Typically, that's what you could do if you're doing a complete overhaul, let's say, of your declaration. An amendment is only effective once recorded in the public records. All right, attorney hiring restriction. And an association may not hire an attorney who represents the management company of the association. That should be a no-brainer, but there you go, it's in the statute. All right, electrical vehicles. Not really gonna, go into detail other than to say that the statute now allows owners to install electric vehicle charging stations in their own parking spaces. So when you get an owner request, and I've seen a lot of these lately, where an owner requests the association to allow them to install a charging station, you pretty much have no basis to disapprove the request, okay? But there are some things that the association can require. Where am I going here? For example, the installation cannot cause irreparable damage to the condominium property. The electricity for the charging station has to be separately metered to the unit owner. The owner who's installing the charging station is responsible for the cost of the installation, the cost of operating, maintaining, repairing, and then ultimately also for removing the charging station if they no longer want to use it. And then the association can also require the owner, for example, to make sure that the installation complies with all safety requirements, any city, county building code requirements. The board can also adopt certain rules, specifications regarding the dimensions, the placement, or external appearance of the charging station, provided that such standards do not prohibit the installation or increase the cost. The association can require the unit owner to also provide a certificate of insurance, naming the association as an additional insured if they want to install a charging station. And then lastly, the board also has the option to install electric vehicle charging station on the common elements if it wants to. Okay. And if you do that, the statute specifically says that that is not considered a material alteration. All right, let's go to disputes. It used to be that the statute, the statute used to require that if there's a dispute between an association and a condominium unit owner, that you have to go through a non-binding arbitration process before you can file a lawsuit against the owner in a particular type of dispute. There's no longer a requirement to go through this arbitration process. The parties can elect to go through pre-suit mediation instead. Disputes that are not subject to pre-suit mediation, that means that if this is the issue that's in dispute, you can go and file a lawsuit against the owner, and those pertain to collection of assessments. Okay, so if you're going to lien foreclose, you just follow the statutory process for filing a claim of lien and then a foreclosure action. An action to enforce a prior mediation settlement, or an eviction action. If you have the authority to evict, unauthorized tenants, you can file an eviction without having to go through pre-suit mediation. Or if an issue is alleged breach of fiduciary duty, an owner can go ahead and file a lawsuit against the board in that regard. Recall and election disputes are also not subject to pre-suit mediation. I've outlined here what the process typically is, but essentially you serve a demand letter on the owner in this case. Let's say they are violating the covenants. You serve them after you send them violation notices and the owner still hasn't complied. You will serve a demand to participate in pre-suit mediation. Okay, which must identify at least 5 mediators. The owner then has to select at least 1 mediator, and there's a time frame within which the mediation has to take place. Disputes that are subject to pre-suit mediation: use of or changes to the common elements or amendments to association documents. For example, if the association, amended a document without without the requisite membership approval, that could be an instance where an owner might file for pre-suit mediation. Membership meetings, not including election meetings, access to official records, covenant enforcements, those are all subject to pre-suit mediation. If there's an impasse, then the aggrieved party, an impasse entitles the aggrieved party to proceed in court without further notice. So for example, if you serve the notice of pre-suit mediation on the owner and he failed to respond or didn't select the mediator, then there's an impasse and you can go ahead and then file the lawsuit against the owner. All right. I've included some slides here about arbitration, non-binding arbitration. It is still an option. Okay, so it hasn't been eliminated. It's not mandatory. Okay, so if the board elects to go through arbitration, I've kind of outlined here the process a bit, which you can read at your leisure. All right, condominium association website. So I'll go through as much of this in the next 8 minutes, and then I'll stick around to answer some questions. All right, so condominium associations having 150 units or more have to have a website for posting of association documents. Okay, and this is basically these bullet points here identify sort of what this web portal will have to look like and what are the requirements. Okay. If an owner requests, if you're required to have a website, then you must provide the unit owner with the username and password to access the portal. And then the statute requires that certain documents be kept on the website. So you have to post the following documents on your website: your declaration bylaws, your articles and any amendments, your rules, your management agreement, annual budget, financial report, the certification of each director, all contracts, okay? And I can tell you, I have defended clients where owners have filed complaints with the division because of the failure of the association to post certain documents on their website. The division does take jurisdiction over those complaints. The association has to ensure that the information and records that are not accessible to owners are not posted on the association website. And we'll talk about what those are in a minute. Okay. However, there's no liability to the association for disclosing information that is protected unless the disclosure was made knowingly or intentionally. So effective July 1st of 2021, okay, the association also now has an option and can instead make these documents available through an app that can be downloaded on a mobile device. The downloaded app must meet all other requirements imposed on a website. Okay. All right, official records. So the statute identifies what your official records must consist of, okay, and has this laundry list, a copy of your plans, your permits, your governing documents, your unit roster, insurance policies, financial accounting records, copy of your question and answer sheet, okay? And then number 14, all other written records of the association not specifically listed, which are related to the operation of the association. This is what is known as the catch-all provision, but notice it's only written records. The association has to maintain the official records for 7 years, except what we discussed, your board certification has to be kept for 5, and then any election materials have to be kept until your next election, so only for a year. However, there are a number of records that, according to a statutory change in 2018, they have to be maintained from the inception of the condominium. Okay, copy of your plans and permits and warranties and other items provided by the developer, your declaration, your bylaws, your articles, your rules, and all meeting minutes. These have to be kept forever and ever and ever until the statute changes. Effective July 1st of 2021, bids for work to be performed or materials or equipment must be maintained for 1, not 7 years. And now renters have the right to inspect and copy only the declaration, the bylaws, and the rules. Now there are certain records that are just not accessible to unit owners, okay, which are in this slide. Records protected by attorney-client privilege. Any information that you obtained in connection with the approval of a sale, lease, or other transfer. So if you have the ability to approve or disapprove sales or leases and you request applicants to submit an application and go through a background check, all those information, all those records in connection with that sale or lease must remain confidential. Medical records, personnel records, okay, of the association or management company employees, including but not limited disciplinary, payroll, health, insurance records. But personnel record does not include an employment agreement. So your agreement with your management company, or if you have an employment agreement with any employee, that is still accessible, even if it discloses, how much you're paying them. Social security numbers, driver's license, credit card numbers, telephone numbers, fax numbers, emergency contacts, those are not accessible. The only way that an email or telephone number of a unit owner is accessible is if the owner has consented to the disclosure of your email, of his email or phone number. Okay. All right, in the 1 minute, let me see if I can just finish the official records. The official records have to be maintained within 45 miles of the community or the county. Okay. When you receive a written request for inspection of the official records, you have 10 business days to allow the owner to inspect the records. The right to inspect includes the right to make photocopies. Okay, but if the owner shows up at the records inspection with a, with a tablet or a scanner, you have to allow them to make copies without charging them. You can charge actual cost of copying. Now, I said that you have to allow access to records within 10 business days after receiving a request. If you fail to do that, then the owner could be entitled to damages. $50 for every day, starting with the 11th day that access to records is denied. All right, it is 4 o'clock. I'm going to stop.
Well,
I
you did
apologize,
cover.
we weren't able to get through all of it, but I mean, I think you've noticed the outline is sufficiently detailed that you can, hopefully read at your leisure. Just clarify while I answer someone else's question. Can a condo association collect a capital contribution from a new owner? So the short answer is no. The division has taken the position that the only fee that can be charged is a transfer fee in connection with a sale or lease, and it's capped at $150. And it really is intended only to cover, the background check of the applicant. During a meeting, the 3 minutes accorded to talk, is that per item? Yes, it's per designated agenda item. The association can also adopt reasonable rules regarding, frequency of questions and, how to, conduct meetings. So, that's an option. How many years can a member serve on? Well, we talked about that effective July 1st of 2018. Board members are limited to serving only 8 consecutive years. So that's from 2018 forward. So you'd have to basically get off the board and then go back onto the board, unless, of course, there's no one else willing to serve. Let's see, when damages are due because of non-compliance, what would be paid by the association or by the offending board member? Would that be covered by any insurance? I mean, very, very general, but I'm not sure who's the non-compliance from. I guess the association. I mean, if a claim is made against the association, depends. You might want to contact your insurance agent and see if the insurance will cover the claim. It would not be out of a board member's pocket. I mean, unless there's, gross negligence or intentional misconduct, fraudulent misconduct, basically. Let's see. We are one-story freestanding homes organized as condos. Do we still need to have a mandatory reserves? So if you are a condominium association, you still have to fund statutory reserves, okay? Unless you give owners the option to waive reserves or partially fund reserves, and you need a vote of the majority of all the owners to waive reserves. Okay, that statutory requirement has not changed. What constitutes a membership meeting? So a membership meeting is a meeting of the owners at which owners will be requested to vote on something. Okay, so yes, the board will be the one that is conducting the meeting, right? You're typically sitting, at a long table, and then the membership is in front, but it's really when you need owners to vote on something. And there are particular issues at which they need to vote. Like if you're amending your documents, if you want to waive reserves. Okay, so that would be a membership meeting. If it's a meeting where the board votes, then it's just a board meeting. We are 12 units. Is there mandatory reserve study required? Well, the reserves that I just discussed, they're still required. If you have 12 units and your condominium that has, that 3 stories or higher. So I don't know if the 12 units are stacked, in 3 stories or across. But if your condominium that has 3 stories or higher, then you have then another obligation, which is to do the structural integrity reserve study.
He clarified, Lewis clarified 2 stories.
Okay. Yes, you still have the mandatory reserves to fund that we talked about. When making amendment to rules, do we need to amend the bylaws, or would informing and having owners consent to it be enough? So when you're amending rules, I mean, you'd have to still look at your documents to see if it requires membership approval, but typically it's a board process. But again, you have to have the authority to adopt rules and amend them in your bylaws. Provided you have that authority, you can amend the rules and then adopt the amended rules at a board meeting. If the rules you're amending concern unit use, you have to mail notice of the board meeting 14 days in advance. If you're amending rules concerning, common elements or facilities, that's just a 48-hour notice. But importantly, with any rule you adopt, once they're adopted, you need to still mail a copy of the rules to all the owners before the rules become effective.
Let's take 2 more. Two more questions, and then because of time, I'll go over the evaluation process one more time and help folks that are having difficulty.
Oh. What's the point of levying fines if there's no way to put a lien or otherwise truly enforce them? I mean, that is a good question. Why didn't the legislature, give us that extra authority, because otherwise, you're right, the lien just sits there.
I said that at the beginning. Some of the laws are pretty good and some of them are wacky and make no sense.
But if you have an issue with short-term rentals, presuming that you have, specific lease terms and they're being violated, then you would enforce it, initially with a demand letter. And if that still doesn't cure the violation, that you might need to get your attorney involved or get an attorney to send a demand letter on firm letterhead. And that might be an instance where you might need to do pre-suit mediation to get the violation corrected. Because failure to enforce your governing documents and rules is a breach of fiduciary duty. So you don't want to be in breach.
All right, one more.
Oh, if you don't have full reserves and it has been waived for 5 years, do you need to have full reserves by 2025, or is it possible to have 10% reserves? That requires a lot of more facts for me to answer, unfortunately. So I won't be able to answer that. Can a member be president and treasurer? Typically, yes, but you'd have to look again at your governing documents. A director can typically serve more than one position. The only ones that can't serve this, only the president and the secretary can't be the same person. And typically, and that's because the secretary, function of the secretary is to attest the signature of the president. So when the president signs a contract, there should be a separate line for the secretary to sign. And, secretary can attest the signature of the president if it's the same person. So that's it.
Wonderful. Before you go, please let everybody know. I know your email is on the screen there, but what is the best way? Do you prefer email? Is that the best way to reach you? And
Sure.
what would you prefer for folks if they need to get in touch?
You can also give me a call. The main number to the office is 954-928-0680. That's our main number, main switchboard, and that's how you get connected to me.
Excellent. Well, thank you so very much.